Hi, this is Sean Murphy of SK Murphy. I'll be your MC for today's PATCA briefing on AI usage best practices by Aaron Austin. PATCA is Professional and Technical Consultants Association. Learn more about PATCA at patca.org. We're fortunate today to have a briefing by Aaron Austin, a seasoned attorney on AI best practices. If you provide services that involve the creation of original designs, strategic decks, creative briefs, positioning statements, brand architectures, taglines, verbal messages, visual messages, or logos, and are considering using AI to create some or all of these deliverables, this presentation is for you. Aaron?
Well, thank you so much, Sean. Thank you all for joining me today. Very excited about this topic. And just to let you know how I got into AI, as frankly an affirmed Luddite, it's never something that I thought I would become the expert in. But it was probably 2 years ago now. I think it could be 3 years because time goes so fast. And I was taking the CLE, continuing legal education credit. I needed one, to meet my deadline, and there's one on AI usage in your law firm practice on there. And I go, okay, I'll have it running in the background while I do get some work done. And I'm kind of listening and I'm kind of listening. And I'm like, it does what? It how? And suddenly I forgot about whatever I was working on. I started paying attention. And at that time, it was, Chat GPT had kind of exploded into the kind of public popular culture. And so they were talking about using ChatGPT in your legal practice. And very interestingly, and I think it was, who was it here? Carol, who mentioned this. I started playing around with it during the course of the CLE. And I happened to be working on a project where I had to, I had one state's law and I needed a similar law in another state. And so I just put it in like, oh, I have this law and I need it under South Carolina law, whatever it was. And it came up with a citation. Here's the law in California, whatever it was. And I'm like, oh, wow, this is great. And so then I take the citation, I look it up, doesn't exist. It completely made up a statute. So we'll find out more about that. But yeah, that was my introduction to AI and how I became what I will loosely term an expert, because I can't actually use that term as a lawyer, is that I am a copyright lawyer. And so I work with experts, making sure they own and control their expertise. And for that, we need copyright law. We're going to talk about that. But suddenly, I found that, AI touches all the parts of what I do in my pre-AI practice. So issues regarding copyright law, issues regarding terms of use, because those are contracts, and then the contracts that we have with our corporate clients. And so we're going to cover all those issues. Now, I know, Darren, you asked about animation. Someone, I am focused on professional services providers and how we use AI in providing service, building our businesses and providing services for our clients. But the issues are applicable to, an animator as well. So first, let's start on copyright law, and everything I talk about will be U.S. law, by the way. I only practice in the U.S., and we're going to take this from the position of U.S. copyright law. So what does copyright law protect? It protects original works of human authorship. And while the two issues where, I got pulled into AI is that originality and the human authorship piece. And so US copyright law is not just implied that something has to be created by a human. It is in the black letter of US copyright law. For something to be protected, it has to be created by a human. And so it has come down to, what does that mean in a world when you have AI generated content? So just to make sure everyone's on the same page about what are copyrights. So copyrights, again, protect the original expression of a human. So when you write something on paper or type it into your keyboard, when you paint a painting, when you chisel a sculpture, when you choreograph a a dance, when you record music, when we have taken whatever that original expression is and we put it in some sort of tangible form on paper, on canvas, recording, it is eligible for copyright protection. And that gives the owner the exclusive rights to do these things, the exclusive right to reproduce it, exclusive right to distribute copies of it. So I'm going to just use an example of a painting. So if someone wanted to reproduce it in, limited series, limited lithographs, I think, only as a copyright owner can you do that. To distribute copies of it, to sell it to the public, only the copyright owner can give permission for that. To make derivative works, if I wanted to take that and put it on a t-shirt or on a cup, only the copyright owner can give permission for that. If it was a script, to perform it, only the copyright owner. To publicly display it, let me take my painting, I can sell it to the person who owns the physical copy and they can put it in their house, but to put it into to publicly display it, that stays the right of the copyright owner, so long as it's protected by copyright. And then to grant a third party the right to do any of those things, those are the exclusive rights of the copyright owner. So that's why we want to have copyright protection for the things that we're creating. So what does it mean in how we get there? So that it requires independence, creativity, and human authorship. Independence is what you think it is. It means it was created independently. You didn't copy it from any other source. It is original to you. The creativity is a pretty low bar. So it's not that it's, the most beautifully written thing or expressed thing. It just has to have a minimum level of really kind of human involvement, which is kind of different than the authorship. I'll get to that. So for instance, just do it. The logo or tagline, just do it, is not eligible for copyright protection because it is not enough expression to rise to the level of creativity. But a very boring, article about some topic that we all know that no one would consider creative would meet that level of creativity because it's just has enough substance to it, even if it isn't creative the way we think about creativity. And so the human authorship is created by a human, and just, pre-AI examples of something that's not considered created by a human. I think we all remember the thing about was it the monkey who took a picture of itself and then someone wanted to copyright it, and no, it's not by a human, no matter what we think about cousins. It is not considered by a human, and so it was not eligible for copyright protection. Anyone can use that photograph. He took elephants that painted paintings, things like that. These are all not considered human authorship. So then we get to AI. So that has been a big deal since AI burst onto the scene and people started using it to create content. And so what recently, and this is actually on the 29th of January, so this is very recent, we've been waiting for the Copyright Office to make an official kind of pronouncement about whether or not AI generated content meets the standards of human authorship so that it can be eligible for copyright protection. And I wish they, I can say they said something new. What they said was basically what we've been saying for the last couple of years when we think about, when we're giving advice about how we use AI. And so nothing really has changed here, but they reiterated that, whether or not something is copyrightable is fact specific. So there's not some magic percentage. It's 10% this and 90% that, therefore it's eligible, or whatever the numbers may be. It has to be evaluated on a case-by-case basis. I will say, having recently submitted copyright applications, registration applications, there is a place there now where it will ask you if anything in there that you're trying to register was AI generated, and you would be expected to disclose that and to exclude it from what you're asking to be part of the registration. So for you and on our day-to-day usage basis, creative prompting, there's a whole new career called prompt engineering, or prompt engineer, I think. And if you play around with AI, you know that the better you are at prompting, the better the output will be. But that, no matter how creative your prompting is, the output that comes out of that AI platform will not be considered human authorship just by virtue of the prompting. It might be for other reasons, but no matter how creative your prompting is, that output is not going to be considered human authorship unless the I'm going to go down to the fourth bullet here since I've made that transition. When the AI tool modifies your original work, then only the perceptible, unaltered authorship that can be separated from the non-human expression, it would be covered. So let's say I have written an original, 200-word blog post, and I want it to create a 1,000-word article from it. And so I put it in. So my prompt in this case, my original work, is copyrightable. It is eligible. It's my original work. I wrote it. It's original. I didn't copy it. I'm a human. It's copyrightable. But then I ask the ChatGPT to create a 100-word article, a 1,000-word article out of it. To the extent it can identify that original input, that's the only part that would be copyrightable. If it's taken the entire thing and completely, created something new with it, then no part of that article, the output, would be eligible for copyright protection. Back up to the third.
Erin,
Yep.
so we did have a question. Ginger, you want to ask your question?
Sure. Thank you, Sean. Erin, your example that you gave about Just Do It was an excellent example because it's something that we're all familiar with, of course. And I wonder under what type of law that particular phrase is protected. I assume it's trademark law as opposed to copyright
Correct.
law?
Correct. Yes. Logos, taglines are protected by trademark law. Correct.
Okay. And how, and I don't want to take you off topic, but can we apply similar concepts about that when we are generating through AI? Or, well, you're obviously going to tell us how to vet our content, I'm guessing.
Yeah, that's actually a good question. I am not completely sure if trademark law requires the logo, whatever you're submitting for protection, to be human created. I kind of think it doesn't, but I'm not sure. I will say that I know that someone who used like a logo generator, to create a logo, and they wanted to get it trademarked, and the logo generator software explicitly stated that you cannot use any of the output to get a trademark. So there's going to be a couple of levels there. So yeah.
All right, thanks.
So we've had two other questions come in. The first question is the prompt that you give to an AI tool, is that copyrightable?
If it meets it's original and it has the minimum level of creativity and created by a human, the answer to that is yes.
And at the risk of opening a can of worms, we got a question: if I edit the ChatGPT output, is the result copyrightable?
Well, that comes us to the next thing. Yes,
There
we're
we
going to
go.
talk about that right now.
Oh, perfect. Oh, sorry. There we go.
That's okay. So I skipped bullet 2. So I'm going to go back to bullet 2, and then, bullet 3, and then bullet 5 will answer the question that was just asked. So let's say I have a report. It's all original. I call it a white paper. Original. It's all me. it's eligible for copyright protection, but I would like to add like a little vignette, like maybe it's about kind of leadership in the work, managing your employees. And I want to put a little vignette in there that like I put in a prompt, like create a, 10-line vignette about inappropriate conversation in the coffee room or something, And so it spits out a little vignette about someone, asking about someone's weekend, whatever. And so that little vignette is AI generated and is part of my white paper. The fact that that is included would not affect the copyrightability of the original part of it. So if I were to try to get that registered, I would disclose that this vignette is not original, it's AI generated, but the rest is original. All right, so now modifying or arranging AI generated content. Unfortunately, the answer is it depends, because again, there's no magic formula. So it will be, how much is, traceable to what the human wrote versus what is not traceable to what the human wrote. And so if you can't really recognize some of the original input in there, it would generally be considered not copyrightable.
We had one more question come in. So if someone is writing a review of a book or an article, or is incorporating it by reference into a work, it's clear that they can copyright the new work. The question is, if the source is AI generated, what's the status of the source of that source document?
So you're using an AI generated article and you're writing a review of that AI generated
article.
Or
you're extending it somehow. So you've got clearly things you're authoring, but then you're trying to reference this ChatGPT output or Perplexity output or Claude output.
Yeah, so any part that you did not write, you cannot claim ownership of. So whether it was created by AI or was something you got off the internet that somebody else wrote, you cannot claim ownership of anything that you did not create. So ideas are not copyrightable. So you read a book, you gives you some great ideas, and you put your brain to it and you write something new. The fact that you got that idea from that book is not a copyright infringement of the book, because you didn't copy from it. You used it to get your brain going. And the same would be the case with if you read something that was AI generated and you use it, that would not be copyright infringement. One, because you didn't copy it, and two, because AI generated content isn't eligible for copyright protection. So even if, but you're right that plagiarism is a different thing. So plagiarism is not illegal, but it is unethical. It's unethical to say somebody else's ideas are mine, right? And so depending on the nature of what you've written, and let's say it was a very unique idea, and you kind of claim this unique idea as your own, then that could be considered plagiarism, but not copyright infringement. Versus if it's like a general one about, leadership. I keep coming back to that one because there's so much written about it. But you have a new twist on it, so that would not be plagiarism or copyright infringement. So I hope I addressed your issue there.
We have someone asking a question from the other direction. They've published information on their website, which has now been scraped by one of the AI tools. Is there a way to enforce the copyright against that?
Yeah, I mean, if you can find where it has been, well, first of all, there's lots of litigation going on from, the likes of the New York Times and things like that, where they've scraped their databases for the training data. And most of us are not going to join one of those actions. So for us, if they have scraped our website and they've put it into their training data, first, I want you to be aware that there are billions of pieces of data in those training data. And the likelihood of the output being a copy is small. You know, the New York Times example where they were trying to show that it was copyright infringement, they had a prompt that was so specific that there was really only one answer that was available for that prompt. And so it spit out basically the New York Times article is, you know, from the prompt. And so look, see, copyright infringement. The likelihood of that happening to any of us is fairly small. Like, why not just get it from the website if we're going to do that? But if for some reason there was an output that was absolutely your work and you found out about it, that you could then enforce your copyright against it, yes.
So someone who's a creator has a question. She says, I want to be ethical, but how do they identify within the total output how much was created by AI or how AI was used? Is there a way that that's identifiable?
Yeah, so when you either claim copyright registration, either, you know, common law or through registration, no one is fact checking you. You know, that's kind of on you to disclose what's yours and what's not yours. What will come up is if a third party steals your stuff and you want to sue them for copyright infringement, and they can say, I got it out of AI. This is not original. This wasn't theirs. Clearly, if I copied what they had, it's because we got the same output from AI, and you're not going to have a protectable right there. You know, and then it will come down to, you know, analyzing what is original in whatever the claimed infringing work is versus, you know, that's yours versus what came out of AI. That's when it would come down to that. There's not a lot of that happening right now. Honestly, I can't point to any current litigation about this. The litigation right now is really focused on the scraping of the internet of very large data sets.
So we have one question and one statement, and then we'll get back to the presentation. So Perry, why don't you ask your question, because it's somewhat detailed and I want you to do it justice.
Okay, mine's going off a little bit on from writing, but I've been experimenting with creating videos from AI. And in one experiment, I gave the AI program some video of myself to create an avatar using my likeness and my voice.
Yes.
Then I gave it a script, original script that I created, and it created a video. I won't go into why the video was unacceptable, but the avatar did look like me saying the words of the script.
Yes.
Okay, so what part, if any of that, is copyrightable? It's my likeness, my voice, supposedly synthesized, of course, my original script.
Your original script is copyrightable as a prompt and as a recording, assuming, you know, you have your own rights. It's not, it is kind of an intellectual property regarding your voice and appearance is yours, and no one can use that without your permission. You know, to the extent it's animated, the animation part would not be copyrightable. But if it really looked like you and everyone would go, that's Perry, when they saw that animation, then that would be considered your appearance, and you would have protection of that and protection of your voice. Someone can't use that without your permission. All right, well, that will bring us to, I think it's our next slide. We can go there now. Yes, terms of use. So we're going to talk about the platforms. We're going to talk about ChatGPT in particular. So let's say your prompt is original to you. You have the copyright ownership of it. However, have you granted a license to that platform to use your work? And I will tell you, Probably, very likely you have. And so they would not be infringing your copyright because you would have granted them a license to use your materials as training data. And so let's talk about terms of use. This is just something that I don't know why, because I've used it for a while. This popped up the other day as and we're using ChatGPT because they have some of the most user-friendly terms of use around. Some are indecipherable, like Zoom, for instance, frankly. So what we're going to do now, and at the suggestion of Sean and Teresa, is like have a quick look at the terms of use of for ChatGPT. So that's ChatGPT's terms of use. If I thought I couldn't screw it up, I'd put it on screen. Let's see here. I think I can do this. Okay, here we go. All right. Do you see terms of use here? Okay, so a number of questions that you have asked. So, and there's more detail for all of these questions. They do have this nice summary of how they use your content, but we're going to talk about that now. About the input, and so that would be the prompts, and the output, what it kicks back out. And so for one thing, they are asking, and this is not unusual, that you are responsible for ensuring that you do not, and that would be including the output, does not violate any applicable law or the terms. And so if you have some output and you don't have a source for it, and you are worried about whether or not it infringes somebody else's rights, it is on you to do the work to make sure that it is not infringing. And so that is on you, and that you make that representation and warranty. For your inputs, you continue to own the rights in it, and you own the output, and they give you all the rights in the output, but we also know that it's not eligible for copyright protection, and they're not making any representations and warranties about it. Like whatever rights, like, I mean, I think this is, whatever we own in this output, you got it, it's yours, but it doesn't really mean anything without representations and warranties behind it. It tells you that it may be similar to what other output it gets, and you let's see, provide where's the training data part? I know it was in here. Our use of your content, so we can use it to maintain, develop, and improve our services. So that is a license. Grant the right to use all the content, whether the input or the output, they have a right to use it. And then there's more detail if you want it there. If you've used ChatGPT, you know that you can opt out of using the content to train models. The difference is that it's not learning for your benefit. So if you have, your ChatGPT and you have a whole string of all your, chats that you've had, and it remembers them. So when you go back and ask a similar one, it remembers those, and it helps, so the next one is based on the last one. For instance, I needed to do a little bio for something the other day, and a year ago I'd used it for a bio, and it remembered what was in there. So you get to opt out of them using your content to train their models, but you lose some of the functionality that probably a lot of us like. And then the accuracy, artificial intelligence is not intended to give you the right answer. That's not even how it is built. It is built to act like a human, right? And it's about language. It wants to talk to you like language. It wants to answer your questions like language. The training data isn't even vetted for whether it's right or wrong. It is, so if you were to go down the hall to a colleague and say, hey, I've got this question, what do you think? And then he would answer you in a certain way. Well, that's what ChatGPT does. And if he doesn't know what he's talking about, and he'll give you a crap answer. And if I didn't know they'll give you a crap answer. So the same way, you need to make sure that you make sure you check the accuracy of anything that comes out. And so, generative AI gets a bad rap for, hallucinating, but at the end of the day, it's just a wrong answer, which people get all the time. And so anything on the terms of use, before I go back. Okay. All right, so let me stop that one and get back to our slides. All right, so we are going to go to using AI with our clients. And so there are a couple of issues, both the information that we're getting from our clients that we may be using in connection with AI, and the deliverables that we're creating for our clients that we may have used AI to create. So here's an example of a provision that I found, and I will say I've been predicting that we would see more of these provisions in client services agreements, and I've seen it twice. So I think I was just ahead of my time, and that 2025 is going to be the year that we see these. But as people understand what happens when their information is exposed to artificial intelligence. So if you have a provision in a client agreement that says, don't do it, you're done. What else is there? Unless you can negotiate it out, you cannot use artificial intelligence in connection with providing the services. But it's more likely that it's going to come up in a couple of areas that we know and see all the time in pretty much every client agreement you're going to enter. First, regarding confidentiality, you'll see something like this, where you can use it. Here, you're the recipient. You can't use it. And by the way, I just want to make the point that confidentiality provisions are both about use and disclosure. It's not just about disclosure. So it's not just about not making it public. It's also that you can only use it for the purpose that's granted in the NDA or in the provision in the services agreement. So you can use the confidential information only to perform the services. This is going to be common, and you can't disclose it. And they might have some things you can, the people who have to use it on an as-needed basis probably would have been cleaner to provide the services. And that's what your obligation is going to be. Now, if you are using AI to take a client's confidential information and send it over to an AI platform to process it in some way, to give you some output with it, and that material you got from the client is subject to this confidentiality provision, this would be a breach of this provision. So we need to be very careful about what our confidentiality obligations are when we are taking the client's information and using it in an AI platform. And so I'm going to, we just looked at ChatGPT. Here is something I just recently, I'm in the middle of a fight for my client on this language that, whoops, where'd it go? So this is a software that helps provide process information that would come, my client gets information from its end client, and it wants to put it into this software because it will, instead of humans doing this processing, this SaaS document can do this processing and help them tremendously. It'd be very, very beneficial, efficient. However, it has this provision in there that they can take the customer data. Oh, why do I keep doing that? And in this case, customer data would include this confidential information that comes from the client that would need to be put into this software in order to get the output that we want. And so it does say, well, we only use it for de-identified information for training and modifying the services, here, down here, for any purpose, very broad. usage of the customer data. But they're like, but it'll be de-identified. So what's the problem? Well, there's a couple of problems. One, not all customer data can be de-identified. In this case, this is using protocols in connection with clinical trials. And so the fact that we don't know which pharmaceutical company's protocol it is doesn't really matter to the pharmaceutical company, does it? So, and they do not expect their confidential information to be used to train some third-party software or to come up with new ideas or for any purpose in this case. So if you're getting information, confidential information from your clients, and you're going to be using it in some sort of SaaS tool, which almost all, frankly, are AI, have some sort of AI functionality these days, you need to read the terms of use so that you know that you're not breaching anything. And then similarly with, I don't know, I have that one, with data protection, again, not all, you may have data that you're getting from the client, I should say personal data that you're getting from a client. And it is subject to, you probably have signed, security exhibits, data protection agreements, private, like all these things. And in the event, and this is language from the client agreement, in the event of having this restricted use, you can only process this data as needed for performing the services. So if we go back here, even if it's de-identified, it's still in breach, because if they've given me their data, I need to process it in order to provide the services, but I do not need to de-identify it to provide the services. I do not have permission to process it to de-identify it. De-identifying information is processing it. So you need permission as well to process it in order to de-identify it. If that's not part of providing services, then even though I would be sending them my data in order for them to provide this service, I do not have the right to let them de-identify it for any reason, because that is not part of providing services to my end client. And so again, you got to read everything. And then representations and warranties. So probably you'll have seen something like this, where you have agreed that whatever the deliverables will be, it'll be original and solely your work. They'll be free from material errors and defects, and they won't violate the rights of any third parties. And so, as we know from just looking at ChatGPT's terms of use, that you cannot, without more, you certainly can't say it's original, which is why even without an explicit prohibition against using AI, you will not be able to meet this end warranty if you use AI to create that deliverable. You definitely want to make sure you're checking it for errors and defects, of course, and making sure that you would not, the deliverable does not violate any third party rights. So, and generally, clients want deliverables that they own and that they have exclusive rights to use. And any AI generated content does not meet this threshold. So a quick summary and then plenty of time for questions. Never include sensitive, confidential, proprietary information in prompts, unless you've read. I mean, again, this is the ChatGPTs of the world. There are absolutely some AI platforms that will say, we absolutely segregate your information. It's not used for training data. It won't be go anywhere. Back to, using it inside of a, law firm environment. When we use platforms that do like contract review, that kind of thing, they all will say, we absolutely do not use the information that you input as training data. Still best practices not to use, trade secrets in there because you just never know, right? I mean, so be aware of any contractual restrictions, either in your client agreements, so that if they explicitly say don't use it, make sure you don't use it. And make sure you're double checking the terms of use of any software that you're using that has AI functionality to know exactly how it's being used. Check and double check your output. Again, they're not intended to be right. They're intended to just provide answers based on what they think should be the right answer. And I mean, they're people pleasers, put it that way. They're people pleasers. And then never use them to create money makers. We didn't talk about that this much, but this is mostly what I talk to people about, is if you want to create something that you want to have exclusive use of, that you can enforce an infringement action against them if they take it, which those things I call the money makers, do not use AI generated content for that, because you will not have access to copyright protections with respect to those materials. So with that, oh, and I never put my contact information. I'll put it in the chat. So I will actually take this down so we can see each other, and then answer any questions that you have.
So we got a question. If a website developer uses AI to create the website structure, but then the developer writes all the text and images, can his customer copyright the website?
Say that one more time. Sorry, I came in.
Sorry. If a website developer uses an AI tool to create the structure, the outline of the website, but then the developer writes all the text and images, can his customer copyright their website?
Yes, unless they want to copyright the structure. For the most part, most of us don't care about if someone steals our structure. We care about the content. And so when you register a copyright, a website, I just did one the other day, where all original content, and basically the way you submit that deposit with the Copyright Office is screenshots of every page. So they do see how it's laid out, but it's covering the content. And because the likelihood that the structure is original, not impossible. I know this group, you keep coming up with exceptions for me, but for the most part, is that structure something that you're worried about someone stealing? Not the content, but the structure. Is that what you're worried about, someone coming and taking and reusing? Is that something that you would hire a lawyer to defend against? And if it's not something that you're going to hire a lawyer to defend against, I would not get overly excited about it. But the content that you would hire a lawyer if someone stole, then yes, you can copyright that.
On that happy note, I want to, Erin, thank you for a great briefing and a lot of good questions, and we'll break here. If you're not a member of PATCA, please consider joining. It's patca.org. Thanks, everyone.
Thank you for having me. It's been delightful.
Thank you so much.
Thank you. Yes, that was excellent. Have a nice day.
Thank you.